Hello, welcome to Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about what happens after you get an approved I-130. I've had different consultations over the years where essentially somebody marries a U.S. citizen, gets an I-130, and then says, okay, I am ready to adjust status. Where do I sign? And it doesn't quite work like that. So I need to inquire into several issues. First, to see even if there's qualification based on the marriage. So I ask first and foremost how the person came into the country, because if you did not come in legally but came in illegally, then you very well may not qualify to adjust in the U.S., minus some very narrow exceptions, one being 245I. If you had a petition filed for you or your family did prior to April 30th, 2001. So for all intents and purposes, if you did not come into the country legally, you're not going to adjust status in the U.S. You're going to have to consular process. I then go into when you got married. There are some people, a lot of people, who come in on a visitor visa with the intention to marry. So they come in on January 10th, let's say, and 2 weeks later they have that wonderful day where they get married, and then they try to apply for adjustment. And ultimately, what happens is not only does that get denied and does the person get put in removal proceedings, they're charged with fraud, okay? Because the visitor visa is meant to visit, is meant to go to Disneyland, have fun, say hello to your friends, and then leave. It's not meant to get into the United States in order to really get married and, stay here forever on the green card. So there's intention issues and so forth. I need to find out if there's an admissibility. So for example, if the person, the beneficiary who got married, do you have any criminal history? When you entered the U.S., even if you entered legally, did you enter with a different name? There's countries where they specialize in coming in on different names so that their real deportability status and their real issues won't be found. So in that case, it's possible to still adjust status, but they're going to have to file a fraud waiver. Are there medical conditions that necessitate a medical waiver? So there's all kinds. Have they been out of status for a certain period of time, necessitating a waiver of the 3 to 10 year bar? Is the permanent waiver in effect? There's all kinds of issues. So first, I find out once the I-130's been approved if they qualify for adjustment in the first place in the U.S. Obviously, you'd prefer to stay here, but in many cases it's either impossible or you have to go outside the country to have a better chance of success. So if it's not possible to adjust in the U.S. with either an adjustment and various waivers if needed, will you be able to go outside the U.S.? So then I determine whether consular processing is available, and if it is, whether you need to do a waiver. And remember I said earlier about the 3 to 10 year bar? Well, on the 3 to 10 year bar, that kicks in the moment you leave the country. It's not a problem as long as you're inside the country and haven't left. But when you leave, you become subject to it. So I need to see, number one, if you qualify for a waiver of the 3 to 10 year bar, and then number two, if we can do a provisional waiver, which means that you can stay here while the petition is pending, and hopefully it will get approved, and once done, you can leave and you might be back within a week. Okay, it's very fast. And the reason it's called a provisional waiver is because when you get it approved, if you're at the consulate and they find something else that makes you inadmissible, the provisional waiver is basically voided, and you are then inadmissible and have to do another waiver. So there are certainly issues in regards to how that goes. So if you get an approved I-130, I can assure you that, and you're married to a U.S. citizen, I can assure you that it is much more difficult to get the green card than a lot of people think. So I've just outlined a few of the issues here today in order to determine whether or not you can adjust status, or you have to consular process, if you have to do waivers. And the typical timelines are consular processing takes about a year and a half, adjustment takes about a year. It all depends where in the United States you are, and it depends if you need waivers and so forth. So if you have questions about these matters, go ahead and give my office a call. I can give you an initial free consultation. You definitely need to have the issues in front of you without thinking that all you have to do is check some boxes and fill out a couple forms and you'll have your green card. It doesn't work like that, and they're really not there to help you. So hopefully you like the video. Click like, subscribe, and more on the coming videos. Thank you.